Mediation is perhaps one of the most misconceived and misunderstood alternative dispute resolution, which then makes it unpopular. We hope that with this video, one can see how mediation can be an effective tool to resolve conflict and hopefully clear all misconception. To encourage us to make more videos like this, please like, share and subscribe. We will really appreciate it. Thank you. Mediation is the act of resolving conflict through the use of specialized communication and negotiation techniques by an impartial party, also known as a mediator. A mediator manages the interaction between the parties and facilitate open communications to assist the parties to analyze issues and relevant norms, also known as reality testing. It is voluntary, confidential, and more cost-effective compared to litigation when results are achieved. Unlike in litigation or arbitration, where only one party wins and the other is left to consider an appeal, the end result in mediation is, hopefully, a win-win situation, which is binding on the parties. Mediation is not counseling. The mediator does not provide an opinion, advice, or a decision. Neither do they arm twist a party to accept a particular position. The mediator also does not act for the parties in dispute but is independent and acts impartially. Mediation is also not a discovery or investigative exercise where one uses it to elicit information or evidence for the purpose of a trial. All communications are on a without prejudice basis. In other words, statements or offers made during mediation cannot be used against the other party in litigation or arbitration later. Most importantly, mediation is not a waste of time or a means to take away one lawyer's rice bowl from litigation or arbitration. One of the most common misconceptions about mediation is that anyone can be a mediator, and therefore the litigants or the lawyers representing them can do it themselves, and there is no need to spend additional money to engage a mediator to do the same. A mediator, like a judge, has to be independent and is someone who has no vested interest in the outcome of the settlement. The fact that the litigants and lawyers representing them are not impartial, they cannot be mediators. Furthermore, not everyone can be a mediator. A mediator is a certified professional who is trained with the necessary knowledge and skill set to facilitate open communication, which includes knowing how to frame the correct, relevant, and impactful questions, knowing how to read the atmosphere in the room and being able to diffuse the situation, and being able to take charge and control the conversation in the room without having to disrespect anyone. The other common misconception is that if the parties are unable to negotiate a settlement, the mediation would also be useless. This cannot be any further from the truth. In negotiation, the litigants are all in fight mode. When one proposes what they think is reasonable, the only thought running through the opposing party is that if such an offer is too far from what they think they would get if they win the case. And there lies the problem. Most litigants think they can win the case, and the only thing they are thinking of is money. Mediation, on the other hand, helps to reduce fight mode behavior to how do I resolve the dispute ASAP and focus on other more important things, behavior. When that happens, the parties are not thinking about winning but how to solve the problem. Furthermore, in negotiation, the relief that the parties are seeking are mostly in dollars and cents, whereas in mediation, the solution can be more flexible, which then provides more options and avenue. So how then can one regard negotiation and mediation the same then? Another misconception about mediation is that it rarely works, and if it fails, it is only going to be an additional cost. Whilst cost for mediation is separate from litigation or arbitration, a simple Google search on mediation statistics will show that mediation success rate is actually more than 80%. In some situations, certain cases may require 2 or more separate mediation sessions in order to see results. Hence, one failed mediation doesn't mean that it won't work again. To some lawyers, this might probably be bad news if the bulk of their fees are dependent on the need for a trial or hearing. It is crucial to remind ourselves that as lawyers, we are in the business of resolving conflicts and are not hired as bodyguards or hitmen for our clients. Well, you know what I mean. Hence, one just needs to know how to provide a fee structure in resolving conflict. Furthermore, the earlier one is able to close his case, the more time he has to look for a new case or work on his other cases. Now that you know what mediation can do for you, isn't it worthwhile considering it whenever a dispute arises? For more information about mediation in Malaysia and the laws governing it, one can visit the MMC, also known as the Malaysian Mediation Centre, to check out the panel of accredited mediators there.